In this trial, the presiding Judge Cisco delivers life sentence to 4 young men, Isaiah Chance, Sean Gathright, DaVon Murphy, and Rashad Murphy after coordinated murder of Jacksonville rap artist Charles Jones, a killing carried out with high-powered assault rifles and a Glock fitted with an automatic switch in a public hotel parking lot.
So, to my city, man, it ain't worth it, boy. Like, it ain't worth it. Like, me being a rapper from my city and Fulio being a rapper from our city, it ain't worth it. Like, my mouth getting dry, sorry. Like, the dissing, the beefing, the shooting, like, for what? Like, for what? Like, when you sitting in your cell alone, cold, it's lonely as hell in that bed. Everybody leave you. Like, nobody here for you. Like, the ones that's your ride or die, your girlfriends, whoever you love, the only person there for you is your mother. And maybe, like, one friend, maybe. But it ain't worth it, though, bro. It ain't worth it. I was 21 years old facing the death penalty. I never ever, my only interactions with law enforcement was traffic tickets. Wake up next morning, I'm facing the death penalty. That's like quit life and change. It ain't worth it, bro.
For what? That was the question the judge asked 4 times from the bench before she pronounced sentence. Not rhetorically, not for effect. She genuinely wanted someone in that room to explain it to her. 4 young men, 1 dead rapper, a public parking lot, high-powered assault rifles, a Glock with an automatic switch, and now 4 life sentences without the possibility of parole. One of the defendants stood at the podium and told her it ain't worth it. He was 21 years old when he faced the death penalty. His only prior contact with law enforcement was traffic tickets. He stood in that courtroom and told Jacksonville it ain't worth it. The judge thanked him for saying it. Then she sentenced him to life. By the end of this video, you will understand exactly how Florida's gang enhancement statute converts what would have been a fixed sentence into a mandatory life term, and why Isaiah Chance's co-defendant received 15 years while he received life. In 2022 and through trial concluding in 2024, in a Florida circuit court, 4 defendants, Isaiah Chance, Sean Gathright, DaVon Murphy, and Rashad Murphy, were convicted of first-degree premeditated murder and conspiracy to commit first-degree murder in connection with the killing of Charles Jones, a high-profile rap artist, in a coordinated armed attack in a public hotel parking lot in Jacksonville, Florida. All 4 were sentenced to mandatory life without the possibility of parole on the lead count. Defense attorneys included Mr. Gonzalez on behalf of Rashad Murphy, Mr. Wise on behalf of Sean Gathright, Mr. Sonardi on behalf of DaVon Murphy, and Mr. Petros on behalf of Isaiah Chance. The state was represented by Prosecutor Dye. The case was presided over by Judge Cisco.
It caught me off guard a little bit, so, okay, but it looks like all of the defendants are present, defense counsel's present, the state is present. All right, are both sides ready to proceed forward to sentencing?
Yes, Your Honor.
Okay, defense, you guys ready?
Yes, Judge.
All right. I know a number of you filed post-trial motions, so let's go ahead and hear those first. All right, Mr. Gonzalez, you can kick it off.
Good afternoon.
The defense raised 7 motions for new trial between the 4 defendants. Sean Gathright was 18 years old when this crime occurred.
Your Honor, I just thank you once again for allowing me the opportunity. I prepared just a little something. I worked kind of pretty thoughtfully on it, so I just ask that you allow your discretion for me to.
Yeah, no, go ahead.
Thank you.
As long as it's respectful.
Yes, ma'am.
All right.
Here we are, being sentenced for the murder of Charles Jones on the day he was killed 2 years later. Now, some may say this is just a coincidence, but I believe that nothing has been, is, or ever will be left up to chance, and that everything in this world is predestined. And there are many biblical promises of that belief holding true.
Jeremiah 1:5 says, "Before you were formed in the womb, I knew you. Before you were born, I set you apart." Jeremiah 29:11 says, "I know the plans I have for you, plans for good and not for disaster." And Romans 8:28 says, "We know all things work together for good to those who love God and are called to his purpose." And there are many more just like them. God has full sovereignty over our lives. He chooses our times of peace and prosperity, our times of joy and laughter. But he also chooses our traumas and our tribulations, not to punish and tear us apart, but to strengthen our character and our faith. Everyone wonders how and why I ended up in a situation like this, despite growing up with a loving family, nice home, multiple opportunities, and promising potential. Some act as if it is impossible or unheard of for someone like me to find themselves in a situation like this. But in reality, it is much more common than we think, and has been happening long before today. There is a parable Jesus shared with the world called the prodigal son, a son who had the nice home, loving family, servants. He had his every need catered to, yet he still chose to take his inheritance and venture off to a far country where he indulged in prodigal living. He soon ran out of money, and a famine had struck the land he was in. And while that would have been enough signs for most to turn back, his eyes still hadn't opened, and he still hadn't come to his senses. Hungry and desperate, he found a job on a farm feeding pigs. And during these times, pigs and what they were fed were deemed as the filthiest, most impure, lowest of the low, and worst of the worst. But he was so hungry and so blind that the food he fed the pigs looked appetizing. That's when he finally came to his senses. He realized that even the servants back home had enough food to spare, yet here he is dying of hunger amongst pigs. After this eye-opening experience, he decided to return home. He was ashamed and planned to go to his father to ask for forgiveness and to become one of his servants because he no longer felt worthy to be called his son. But when he returned, his father embraced him with love and compassion, dressed him in the finest clothes and jewels, and celebrated his son's return with a feast, exclaiming, "This son of mine was dead and has come back to life. He was lost and is now found." It is not uncommon for good young men who come from good families to get lost in this world. But discontentment often leads these good young men astray. When scholars and historians look back on our times, I believe they will label us as the age of discontentment. And those of us who come from privileged upbringings are actually disadvantaged to the fight against it. Because of the high expectations, many opportunities and options we grow up with, we don't know what struggle looks like, or how hard our parents had to work to provide these opportunities for us. We don't know what we have until it's gone. And it often happens after we go through our own eye-opening experience. Never in history has there been a time like now where there is so much available and so easy to consume, but we still demand more. And it is clearly seen in my generation. Young men and women want to grow up faster to try to keep up with the influencers that are idolized. And this is in part due to us being so susceptible. A study done by the National Institute of Mental Health provided evidence showing that the brain doesn't reach full maturity until 26 to 27 years old for men, about 8 or 9 years older than my time during the offense. But society knows this, and that's why laws set age requirements on certain activities, amenities, and substances as a way to protect adolescent adults. Yet those same laws don't extend to an adolescent adult when they are charged with crimes and allows them to be prosecuted to the fullest extent, regardless of their age. Your Honor, it is heartbreaking that an 18-year-old can't rent a car or a hotel or buy a home, but can be sentenced to death or life in prison without the possibility of parole. They can't purchase alcohol or tobacco, but can be sentenced to death or life in prison without the possibility of parole. They can't work certain jobs or even go on a cruise without a chaperone, but can be sentenced to death without life, or life without prison, in prison without possibility of parole. And I'm a prime example of these circumstances. At 18 years old, with no prior convictions, I was charged, indicted, and had to face the death penalty. My point is, society views anyone under the age of 21 as not being mentally mature enough to participate or partake in these activities, amenities, and substances, because certain substances listed can negatively impact or stunt the growth of a developing brain, while other activities and amenities have restrictions due to the lack of impulse and behavioral control or lack of situational awareness at times with teens. It is very simple to understand that our brains have not developed enough, that we live in a society where someone under the age of 21 can be sentenced to death or life in prison without parole. We leave no room for growth, rehabilitation, or redemption. We don't account for the fact that they weren't a fully developed adult and their judgment and decision-making abilities weren't developed either. I believe it is cruel for someone under the age of 21 to be sentenced to life without parole or death before they're even old enough to be fully emancipated or to fully comprehend what consequences their actions carry. I say all this because I want to see change. Change for those whose fates were sealed long before they were born. Change for the prodigal sons and daughters who ventured off too far in the world and got lost. Change for those who haven't reached full maturity or unlocked their full potential as adults. Change for the ones who never had the option to go around, over, or underneath, but straight through their obstacles. In spite of my current circumstances, I still trust in all those biblical promises. And I believe that I am exactly where God planned for me to be, a plan He created long before I was born. It is also my belief that this chapter of my life will propel me to a much greater purpose than what we see here today, because my journey has just begun. Thank you.
Thank you, Mr. Gathright.
He had grown up in a stable home, had opportunities most defendants standing before a sentencing judge never had, and described himself at the podium as a prodigal son who had wandered too far from what he knew. Isaiah Chance was 20, one with no prior criminal record. His only previous contact with law enforcement was traffic tickets. DaVon and Rashad Murphy came from harder circumstances. The judge acknowledged it openly, and they faced the same sentence. All four men had children.
What would you like to say, Mr. Murphy?
I would like to say to God be the glory, and all the time, and be forever have the last say so.
I'm sorry, Judge. I'm sorry.
You know, you may have to step up to the podium because the court reporter just needs to hear what you're saying, Mr. Murphy.
As I was saying, yeah, it look different from up here. Okay. To God be the glory all the time, and He'll forever have the last say so in our situation. As I said in my interrogation interview, I'll be judged for it, and I'll forever retain my innocence. And I just want to say to the Gen Z generation, change your life and do something productive with your life, because in this predicament it ain't worth it. And like it was said before, this is not my first rodeo down this road, so it's looking like forever, but I'll forever keep a positive mind state and a positive mindset. But to God be the glory forever. And that's it.
Thank you, Ms. Murphy.
All four families sat in that courtroom. The weight of mandatory life without parole, the legal foreclosure of every year of every life that had not yet been lived, is not an abstraction. It is the distance between the person who stood at that podium and the person who will die inside a Department of Corrections facility. The prosecution's case at sentencing was built on the totality of what the trial had already established. 3 armed men with high-powered assault rifles and a Glock fitted with an automatic switch, a device that converts a semi-automatic handgun into a weapon capable of firing rapidly and continuously, carried out a coordinated targeted killing in a public parking lot. The victim was a high-profile rap artist. The state argued the manner of the crime itself established that every person involved knew a high-profile homicide investigation would follow. The crime was caught on video. The defendants were caught on video. One of them was caught on video wiping down the interior doors of the vehicle used in the crime before leaving it at his grandmother's house the same day. Phone evidence documented each defendant's activity in the immediate aftermath. The state presented what it described as a mountain of evidence, not primarily circumstantial, but direct, documented, and caught on camera. The defense raised 7 motions for new trial between the 4 defendants, covering cell phone suppression, statement suppression, denial of severance, gang evidence admissibility, improper expert opinion testimony, spillover prejudice from a joint trial, and the weight of the evidence overall. The tampering charge against Sean Gathright, based on the wiping of the vehicle's door interiors before leaving it with his grandmother, generated a separate motion for judgment of acquittal that the defense argued to the very end. The defense's position was that wiping 2 door interiors while leaving 90% of the vehicle available for forensic examination, and then continuing to drive the vehicle on a public street before parking it, was not consistent with intent to impair evidence availability. The state's position was that he was caught on video doing it, and that anyone who had just participated in the public assassination of a high-profile rap artist knew a law enforcement investigation was coming. Most people watching the sentencing hearing focused on the family's statements and the defendant's words at the podium. Here is what almost nobody in that room commented on publicly. Isaiah Chance told the judge directly that his co-defendant Alicia Andrews, who allegedly played the same role Chance was convicted of, went to trial separately, was convicted of manslaughter instead of murder, and received 15 years.
It was something this absurd, especially being this young. This is harder than what I intended. I'm gonna be honest. I feel like our appearances here were more political based than solely on our 6th and 14th Amendment, which guarantees our right to a fair trial with an impartial jury for each defendant. Being that, I'm not gonna say, I wanted to say something to you directly.
No, that's fine, and you're more than welcome to disagree with any way I may have ruled in the case. You just can't
Repeat the facts.
Yeah.
Yes, ma'am.
Yeah, you don't need to repeat the facts, but you just can't be rude to me. That's all I'm asking. You can express disagreement. I have thick skin, and there'll be an appellate review of everything I did, but just don't be disrespectful, because then I'm gonna have to tell you to sit down, and it becomes a thing. So
Yes,
let's
ma'am.
just not have a thing.
Yes, ma'am. All right. Okay. So, thank you. You all right. So, Judge Cisco, unlike the rest of my co-defendants here, they all are charged with being the alleged shooters and have the same verdicts. However, me, on the other hand, the one who was charged with me for playing the same alleged role as I, gets found not guilty for what I am charged with. Alicia's case didn't contradict the alleged shooters versus the state case. I don't even think it's possible it could have. However, it contradicts mine being the only principle here, because both of our jury's decisions contradict each other. The only nuance is I went to trial with 3 other people who have the same verdict as I, and she didn't. Alicia get found not guilty for my current charge. It wasn't a coincidence. Basically what I'm saying is Alicia and the state alleged that we played, that's getting into like the facts of like the case.
Well, that's okay. If I'm hearing you correctly, you are taking issue with the fact that I don't know if she's your current or former girlfriend, but she went to trial. She was convicted of a manslaughter and got 15 years, and now you're here facing life. And that, I would assume, that seems unjust to you. Is that correct?
That's highly unjust. I seen Susie Lopez on the news this morning, and she was saying that justice has been served. Absolutely, if you see it from that perspective. But everything that's a perspective is based off perception. So if you say that's justice, okay, but when you look at, if you put me and Alicia up on, like, side by side, that's unjust, like it's injustice, like it doesn't make sense, like it's contrary to my verdict. Like her jury made their decision, my jury made, well, our jury made their decision, but it contradicts like both of our verdicts. The only difference is like I went to trial with my co-defendants and she went to trial by herself. So I feel like personally, I got guilt more so by association than like participation. That's all I really wanted to say, Judge. Sorry, because this is way more harder than I anticipated. But that's all, thank you.
Chance received life. 2 people, same alleged role, different trials, opposite outcomes.
I anticipated. But that's all, thank you.
Sure, sure. And you probably know when Miss Andrews went to trial, she basically pinned it all on you.
Absolutely, yeah, I know. You know, when as I sit with my lawyer, like he's very, like he's probably shivering over there because he don't know what I'm gonna say out my mouth.
Right, he's very concerned.
Yeah, definitely. A lot of people don't know, but before you go to trial, you try to be optimistic, but everything is done strategically. So how the lawyers optimize what they're gonna say or what they're gonna do, they do it with the client. You know, I'm not saying what she's saying was wrong or not wrong, or what he wanted her to say, or what she said. You know, but that's all.
That disparity passed without legal resolution in the sentencing record. It will become the factual foundation of every appellate argument Isaiah Chance files for the rest of his natural life. Under Florida Statute 874.04, Florida's Gang Enhancement Statute, formerly known as the Street Terrorism Enforcement and Prevention Act, a jury finding that a defendant committed a felony for the benefit of, in furtherance of, or in association with a criminal street gang can elevate the offense level of the underlying charge. In plain English, a gang enhancement can convert a first-degree felony, which carries a maximum of 30 years, into a life felony carrying a maximum of life in prison. For DaVon Murphy and Rashad Murphy, the jury found gang enhancements on the attempted murder counts, which elevated those charges from first-degree felonies to life felonies. That is why the prosecutor told the judge the attempted murders carried life sentences rather than 30 years for the Murphy defendants. Most people who followed this case assumed all 4 defendants faced the same sentence structure because they were convicted of the same lead count. The gang enhancement created a legally distinct sentencing landscape for those defendants against whom the jury returned that finding. That distinction passed without extended public explanation during the hearing itself. The defense's argument on the tampering charge built its entire foundation on the specific intent element of Florida Statute 9-18.43. That statute, which defines the crime of tampering with physical evidence, requires not just that a physical act was taken with respect to evidence, but that the act was done with the specific intent to impair the evidence's availability or admissibility in a criminal proceeding. The defense argued that leaving a car with a grandmother who was not told to hide it, who proceeded to drive it normally and was subsequently pulled over in it, was legally inconsistent with specific criminal intent. The defense cited the Costanza case for the proposition that equivocal conduct toward evidence, conduct that has an equally plausible innocent explanation, is legally insufficient to prove the specific intent element. The state countered that the defendant was on video wiping the doors, that the crime was a public high-profile targeted killing, and that no argument could credibly claim the defendant did not know law enforcement was coming. The motion was denied.
Ms. Doherty, what's your response first to Mr. Gathright's the motion for judgment of acquittal as to count 6, the tampering charge.
Judge, we did review that case law that he cited as authority in his motion as well, and Judge, those cases are clearly distinguishable by to the facts presently in front of the court. One of them was a corpus case. We literally have the defendant on video where he is seen actually wiping down the fingerprints. All of the rest of the cases went towards knowledge, intent that that physical act was actually done and proof of that. And Judge, there is circumstantial evidence in this case that is overwhelming. This is a case where the manner in which the homicide occurred was at a hotel, a public spot where 3 armed gunmen used high-powered assault rifles and a Glock with a switch that was automated to be able to fire rapidly and unloaded in a public parking lot. And this was the victim in this case. There is ample evidence that they knew who they were targeting. They knew the high-profile nature of the victim. And so, Judge, the law requires for tampering that they knew or should have known that a investigation by law enforcement was going to occur. There is no argument that they can make based on the circumstantial nature, the manner in which they committed this crime, to suggest to this court that he did not know that a law enforcement investigation was about to be instituted, and the actions that were done with both of the vehicles that were used in this case clearly were removed from the state of Florida, and where they live in Jacksonville and where they would be investigated, they were removed from that city. They were hidden. That car was hidden at his grandmother's house the day of the homicide. When the homicide occurred, he brought it and he switched vehicles and switched contents that was contained within the suspect murder vehicle and put it into another vehicle, Judge. Based on the facts and the circumstances in this case, we believe that there is enough facts and evidence to support that he knew that a high-profile investigation, homicide investigation would occur. There was all the phone evidence from his phone that showed his activity immediately after this crime. So he certainly knew that they were successful in killing a high-profile rap artist. So based on that and the fact there is no corpus issue in this particular case, he literally is seen wiping it down on a video. So based on all of that evidence, we would ask that you deny the defendant's motion.
Okay, and do you have any further argument on any of the defendant's motions for new trial?
Your Honor, we would rely on all our previous written arguments as well as oral arguments that were made in pretrial motions and during the course of the trial. Any weight arguments or insufficient evidence we believe is without merit. The facts and evidence in this case were overwhelming. There was a mountain of case, not only circumstantial evidence, there was direct evidence of each and every one of the defendants' participation in this case, as well as the actual crime itself.
A competent pre-trial defense team handling these cases would have filed aggressive motions under Florida Rule of Criminal Procedure 3.152, which governs severance of defendants, and would have developed a more precise factual record of what specific evidence against each individual defendant would not have been presented in a separate trial. The risk of a joint trial is jury confusion and spillover. The documented danger that evidence presented against one defendant becomes emotionally associated with all defendants in the jury's mind, regardless of individualized instructions. The defense raised it. The court denied it. The consequence is that Isaiah Chance now faces the identical sentence to defendants against whom the evidence was substantially different, and his best remaining legal argument is exactly the disparity he articulated at the podium, that a codefendant who allegedly played the same role, tried separately, received 15 years while he received life. Most people assume that once codefendants are tried together, their sentences will reflect their individual levels of participation. Florida law does not guarantee that. The joint trial risk is real. The consequence it produced here is visible in the record. Florida Statute 874.4 was the legal mechanism that most directly shaped the sentencing disparity in this case. The gang enhancement is what the cross-examination of the gang expert witnesses challenged through multiple Daubert motions that the court denied, was ultimately designed to prevent from reaching the jury. The defense's entire pre-trial motion practice on gang evidence was aimed at the sentencing consequences that would follow if the jury found those enhancements. They lost those motions. The jury found the enhancements. The sentences reflect exactly what the defense had argued would happen if they did. Most people believe that gang evidence in a trial is simply background context for a crime. It is not. In Florida, under the STEP Act, a jury finding on gang enhancement is a sentencing trigger that can double or eliminate the statutory ceiling on a defendant's exposure. Understanding that is the difference between watching a sentencing hearing and understanding why the numbers came out the way they did. The prosecution stood on the record and rested on what the trial had already established. Charles Jones was targeted and killed in a coordinated public attack. Every defendant's participation was documented on video. The phone evidence placed each defendant in the relevant locations at the relevant times. The jury had heard everything, deliberated, and returned verdicts of guilt. The sentences that followed from those verdicts under Florida mandatory minimums and gang enhancements were not judicial discretion. They were the mathematical output of the law applied to the facts the jury found. The defense argued that cumulative error, the combined effect of the denied severance motion, the extensive gang evidence, the expert testimony on gang affiliation, the spillover from a joint trial, and the spontaneous admission by a codefendant that the jury heard, had deprived each defendant of the fair trial the 6th and 14th Amendments guarantee. They argued the verdicts rested on impermissibly stacked inferences rather than direct evidence of individual intent. And Isaiah Chance, standing without legal counsel's full blessing at the podium, made the argument the appellate courts will hear for the next decade that his co-defendant Alicia Andrews was convicted of manslaughter and received 15 years for the same alleged role for which he received life, and that the only legal variable between those two outcomes was the composition of the jury and whether the defendant went to trial alone or alongside 3 others who received the same verdict. The one question the judge was not required to resolve before imposing sentence, because mandatory life foreclosed her discretion, was this: does the difference between a life sentence and 15 years for 2 defendants who allegedly played the same role in the same crime constitute a constitutionally cognizable disparity? And if it does, at what point does the 6th Amendment's guarantee of an impartial jury become incompatible with a joint trial that produces that outcome? All 4 defendants, all 4 motions for new trial, denied.
All right. So I will deny Sean Gathwright's motion for judgment of acquittal as to count 6 and deny all of the defendants' motions for new trial.
The judge delivered her rulings without extended analysis because she had already ruled on every issue during trial. The sentences followed from the verdicts as a matter of law.
You know, I really don't know what to say about what's going on in Jacksonville. Again, and I don't know if it's getting better or not, but I was stunned. And when I was sitting there listening to the evidence and just the trail of dead bodies, just one young man after the next, just cut down in the prime of their lives. I mean, it's shocking. It is shocking. And I just can't believe that any community, if they're made aware of it, will stand by and put up with that. I mean, it's just tragic. And, you know, Mr. Jones did not deserve to die for what he did or what he drilled, the drill rap videos he made. But goodness gracious, going and desecrating the gravesite of a murdered relative is, you don't deserve to be killed for that, but you just increased your odds that it was going to happen. And that's the truth. That is the truth. So I'm not at all, again, stating that he deserved it, but it's just shocking. It's shocking to me. And I do have great sympathy for the defendants. You all, for the most part, are young men. and some of you have children. And now for what? For what? Now you're looking at life in prison. And what was it for? And I really appreciate Mr. Gathright and Mr. Chance really speaking to your community. Like, these decisions that are made can have unalterable changes that you can't come back from. There's no coming back from them. You either end up dead or incarcerated for life. And I feel like, you know, you gentlemen had much more to offer this world. You did, and you do. And so, in particular, you know, Mr. Rashad Murphy and DaVon Murphy, listen, there's no question you guys had a difficult childhood. There is no question. The hand that you were dealt from Jump Street was not the best. There is no question about that. Again, it's not an excuse, but I do acknowledge it. Mr. Chance and Mr. Gathright, you all, unlike the Murphys, you all did have positive role models in your life. Mr. Chance, you had a dad that testified and appeared to be a good role model, and a stepfather that cared about you. And Mr. Gathright, you, as you acknowledged, you had so many opportunities that most people don't have. I mean, you started off, the hand that you were dealt, the cards that you were dealt were pretty good. They were pretty darn good. Better than the average person. So it's particularly hard. I am heartbroken for you. I'm heartbroken for your family members. I'm heartbroken for your children. I am. So I do have great sympathy. But you have been convicted, and it was a horrible crime that was committed, and there is a price to be paid, and there's just no way around that. I do find it remarkable, and I hope that you can maintain your positive outlook. Each of you still has a life of value. And going forward, the quality of the life that you have every day will come down to the choices you make. And so I hope that you continue to make choices, and then you realize you do have value and you can contribute. And you started today by speaking to the members of your community, particularly the younger men, that this is not the way to go. It's not. It's not. Because look, we have Charles Jones is dead and 4 people who will now spend life in prison. And again, all for what? For what? Nothing. Over nothing. Turf warfare, drill rap videos. I mean, it really is nothing. So one thing I found that was, when I was listening to the testimony, I think when Robert Howard testified, he testified that Jacksonville was the new little Chicago. And I almost fell out of my chair, because I can't even imagine anyone in Jacksonville wanting that comparison. So I was curious. I looked it up, and who knows if this is accurate, but apparently in Chicago last year, there were 406 homicides. A quarter of that was gang-related. That's about 104 people. Dead. Poof. Gone. Gone. For what? For what?
The sentence is constitutionally correct under the framework the Supreme Court established in Apprendi v. New Jersey, 530 U.S. 466 2000er, which held that any fact other than a prior conviction that increases the penalty for a crime beyond the prescribed statutory maximum must be submitted to a jury and proved beyond a reasonable doubt. The Florida gang enhancements that elevated DaVon Murphy's and Rashad Murphy's attempted murder counts to life felonies were submitted to the jury and found beyond a reasonable doubt. The mandatory life sentence on the first-degree murder count required no jury finding beyond the verdict itself. First-degree premeditated murder in Florida carries mandatory life under Florida Statute 775.082 without judicial discretion. Every sentence imposed was within the statutory framework Apprendi requires. The disparity between Alicia Andrews' 15-year sentence and Isaiah Chance's life sentence is not a constitutional violation under existing law. It is the documented product of separate trials, separate juries, and separate factual findings. That distinction is constitutionally permitted. Whether it is just is a different question. A murder conviction does not resolve the question of what made it possible. Jacksonville lost a rap artist to gang violence, 4 young men to life imprisonment, and 4 families to the long mathematics of incarceration. The law answered what the verdict required it to answer. What it could not answer was how a 21-year-old with no criminal record arrived at that podium facing a sentence that ends only when he does. Coming next, we examine the specific legal mechanism by which a Florida appellate court reviews a joint trial's denial of severance, and how courts distinguish between prejudicial spillover that requires reversal and the ordinary disadvantage of being tried alongside codefendants with more damaging evidence against them. Was Isaiah Chance's life sentence the legally correct outcome of a jury trial that produced a conviction on first-degree murder regardless of how the evidence was presented, or does the documented fact that Alicia Andrews received 15 years for the same alleged role in the same crime, tried separately, expose a structural failure in Florida's joint trial rules that the Sixth Amendment's guarantee of an impartial jury was designed to prevent? And if you believe it does, what legal remedy should actually exist for a defendant whose sentence is shaped not by his own conduct, but by the composition of his trial,